Thanks to all of you for being here and those on the phone. I think this press conference has set a record for largest number of attendees at the press conference, and I think that speaks to the importance of this issue and how serious we take it as an office and all the organizations and individuals who are here, who I'll be introducing shortly. My name is Bob Ferguson, Attorney General, and as you know, on Friday, the United States Department of Health and Human Services released a rule that will eliminate funding to Title X family planning providers who, using non-Title X funds, also provide abortion services. We're here today to announce that we will shortly, after this rule is published, be filing a federal lawsuit in the Eastern District of Washington challenging this transparent attack on Planned Parenthood and assault on Washington women. Once again, and we've been here before, President Trump is violating the law. This time, he is inserting his politics between a woman and her health care provider. President Trump's Title X rule is unacceptable and unlawful. The rule prohibits providers from referring patients for abortion care. It requires providers to refer pregnant patients for prenatal care even if the patient does not want or need that type of care. And it requires Title X clinics to physically separate their family planning functions from any abortion services they provide. If implemented, the Trump administration's new rule will reduce women's family planning options, interfere in doctor-patient relationships, and inevitably leave many vulnerable women with no health care access at all. This rule, as released on Friday, and will be formally, this rule was released on Friday and will be formally published, frankly, at any moment, imminently. And that could happen as soon as today. The rule is set to go into effect 60 days after it's published. Compliance with various aspects of the rule is staged to allow healthcare providers between 60 days and 1 year to fully comply. Shortly after we file our lawsuit, we will be filing a motion for a preliminary injunction, which asks the court to block implementation of this rule before it goes into effect. We will file for a preliminary injunction well before the 60-day clock is up to make sure this rule never goes into effect. You've seen us do this before on a variety of issues where we file a motion for preliminary injunction to stop the actual implementation of the rule before it can go into effect. We've been successful at that. The Dreamers case, for example, the President's decision to terminate the DACA protections for Dreamers has never gone into effect because of successful litigation placing an injunction on that decision. In short, the government should not tell patients what medical care is right for them. These sensitive decisions should remain between patients and their medical providers. The Trump administration's new rule interferes with that relationship and with patients making well-informed healthcare decisions based on complete, unbiased information. We will not allow the federal government to dictate what a provider can or cannot say to a patient. So I'm going to make a few introductions. We will not introduce, of course, everybody who's here today, but I want to introduce a few folks, in particular some speakers and some folks on my legal team here who are with us here today. First, Aaron Berry from the Washington State Medical Director of Planned Parenthood of the Great Northwest and Hawaiian Islands. Planned Parenthood is arguably affected by this rule more than any other organization. Dr. Deborah Oyer, Medical Director of Cedar River Clinics here in Washington State. Cedar River Clinics are a major component of our Title X network. Emily Chang is the Legal Director of ACLU Washington. Claire Coleman is President and CEO of the National Family Planning and Reproductive Health Association. If you hear us refer to NFRA, that is NFRA. That's the acronym that we use. She flew from Washington, D.C. to be here today. We so greatly appreciate her taking time to join us. Claire's organization, NFRA, will be filing their own lawsuit, also in the Eastern District of Washington, against this rule. We anticipate that the two cases, NFRA's and the state of Washington's, will be consolidated at some point throughout this process. I want to emphasize we've been working with all these organizations now for many, many months as we've been preparing for this potential litigation. I'm also joined by a number of folks from my legal team, Assistant Attorneys General Kristen Beneski, Jeff Sprung, Paul Crisali, Legal Assistant Ali Hollenbeck, and Solicitor General Noah Purcell. My team's been working extremely hard to put this together. Look, it's relatively easy to stand in front of you and announce a lawsuit, all the work that goes into it. It's many, many, many hours, many weekends, a lot of work to be prepared so that when this rule is formally published, we're ready to go right away. That is important to me. As we just were discussing beforehand, we kind of had a gathering, and it's important to me to communicate to the people of the state on big issues like this that impact their legal rights. and in this case, their medical care, that the people of the state know that my office is ready to challenge those unlawful decisions immediately. We're also joined by many folks who are very involved in healthcare access for women in Washington State. A special thanks to South City Council member Lorena Gonzalez, who is in this crowd behind me somewhere. Thanks for being here. I also want to thank Governor Jay Inslee, who can't be here today, but I'm fortunate to have a governor who supports in so many ways the work of our office in challenging this administration, providing resources and assistance in many, many ways, and we greatly appreciate the governor and his administration's support. So I'm going to give you a little background on Title X, a bit more details about our case, then you'll hear from other speakers, and then we'll take your questions. Title X, as you know, is a federal grant program. It helps ensure access to affordable, preventive reproductive health care. Congress enacted Title X in 1970 in an effort to reduce the rate of unintended pregnancies and break the cycle of poverty, ensnaring women who are unable to pay for effective contraception. Title X passed the Senate unanimously. Every year, for the last 22 years, both Democratic and Republican-controlled Congresses have approved Title X funding. And it's easy to understand why. Title X programs serve an estimated 4 million women annually across the United States. More than 2/3 of these women have income at or below the federal poverty line. In addition to family planning care, Title X providers also screen for high blood pressure, diabetes, depression, and cancer. For 4 out of 10 women who receive contraception care from Title X funded and other similar facilities, this is their only source of health care. Title X funding is not only essential for reproductive health care, it's essential for health care, period. In Washington, more than 91,000 patients, both men and women, received care through the Title X program in 2017 alone. More than half of these patients were at or below the federal poverty level. The Washington Department of Health estimates that services provided to these patients prevented more than 18,000 unintended pregnancies and over 6,000 abortions. Title X provides funds for 85 clinic sites in Washington, operated by 16 organizations. 1/3 of the funding for family plan programs in Washington comes from the federal government and Title X. This rule will force out of the program professionals who provide nearly 90% of Title X family planning services to Washington patients. Rural communities in Washington currently have a shortage of healthcare providers. This rule will make this shortage even more acute and leave Washingtonians in 21 counties without access to a Title X provider. 11 of those 21 counties are in eastern Washington, where we are filing our lawsuit. The rule makes 2 unlawful changes to the Title X family planning program. First, something that's referred to as the Gag rule, and second, a physical separation requirement. I'm going to briefly outline those for you. The Gag rule allows providers to refuse to provide patients with information regarding their reproductive health care needs, even if the patient is requesting that information. It requires Title X providers to refer each pregnant patient into a prenatal care program regardless of the patient's wishes or the provider's medical judgment. It prohibits Title X providers from referring patients to an abortion provider even if they request one. Imagine what this might look like as a patient. You visit a Title X clinic and learn you are pregnant. If you ask for an abortion referral, the provider is legally prohibited from honoring your request. Bottom line, the Gag rule unlawfully inserts politics between patient and doctor. That's what this is. The Gag rule violates the Affordable Care Act, which protects providers and patients from government interference in the healthcare relationship. The Affordable Care Act states that the federal government cannot impose a rule limiting, I'm quoting now from the Affordable Care Act, our law, limiting, quote, the ability of healthcare providers to provide full disclosure of all relevant information to patients making healthcare decisions. The Gag rule directly violates this provision by allowing Title X providers to withhold information about abortions, regardless of whether a patient wants to know about this option, and prohibiting them from providing referrals to any type of specialized healthcare provider. The Gag rule also defies the requirement set by Congress that, quote, all pregnancy counseling, end quote, provided using Title X funds, quote, shall be non-directive. In other words, providers must neutrally present all options and accurate information and not push patients toward one option over another, non-directive. That's what the law says. This mandate is part of the Appropriation Acts passed annually for the past 22 years by both Democratic and Republican-controlled Congresses, including the one from last year. The gag rule allows providers to deny patients information about their healthcare options, a direct violation of this mandate. The gag rule is also unconstitutional. It violates the First Amendment rights to free speech, silencing doctors, and depriving patients of medical information. The rule's second harmful component, the physical separation requirement, requires clinics that also perform abortions or that refer patients to abortion providers or talk to patients about abortion to create a physical wall between their family planning functions and their abortion services. The rule requires separate entrances and exits, treatment facilities, contact information, websites, personnel, and healthcare records. Currently, providers cannot use Title X funding for abortion services. Currently, all Title X funded providers that also offer abortion services must separate these services financially from the Title X funding they receive. Forcing providers to find or create separate facilities to perform their abortion services and referrals from their Title X activities jeopardizes some clinics. This requirement will force most Washington providers to forego Title X funding altogether. As I stated earlier, it will leave 11 eastern Washington counties without any Title X providers. As a result, some Washingtonians will need to travel hundreds of miles to receive their family planning care, while some will lose access altogether. This particularly affects the uninsured, low-income, and rural women that Title X was designed to benefit most. This physical separation provision transparently and arbitrarily targets Planned Parenthood. In 2016, half of Planned Parenthood's visits were Title X. It's also unlawful and unconstitutional. It violates the Affordable Care Act, which prohibits the federal government from imposing a rule that creates, quote, any unreasonable barriers to the ability of individuals to obtain appropriate medical care. It also violates patients' due process rights under the Fifth Amendment by imposing health regulations that are a substantial obstacle to obtaining an abortion, a freedom protected, of course, by Roe v. Wade. So now I'd like to invite Erin Berry of Planned Parenthood to say a few words. Planned Parenthood has been a fantastic partner, as you might imagine, on many issues for this office, and on this issue in particular, and we're really honored to have Erin here today. Erin.
Thank you so much. All right. Thank you so much, Attorney General Ferguson, and thank you all for being here. My name is Erin Berry, and I'm the Washington Medical Director for Planned Parenthood of the Great Northwest and Hawaiian Islands. Every day, I provide Title X patients in Washington with much-needed cancer screenings, birth control, screening and treatment for sexually transmitted infections, and pregnancy testing. It's my job to make sure that my patients have the very best information and care available so that they can make the decisions that's best for themselves. I'm passionate and grateful to have the honor of helping people pursue a healthy and happy life. The Trump-Pence gag rule needs to be challenged because it blocks doctors like me from being able to refer their patients for safe, legal abortion. As a doctor, I cannot imagine withholding information from my patients. It's unethical, and it flies in the face of the oath I took to take care for my patients. It threatens the doctor-patient relationship. It prevents patients from having the full and honest information about all of their healthcare options. Politicians have no business telling me what I can talk to my patients about. This rule is shameful, and it's dangerous. But the gag rule doesn't stop there. The rule has another dangerous provision that's specifically designed to block people from accessing birth control, cancer screenings, and other reproductive health care at Planned Parenthoods and other Title X providers. Planned Parenthood serves the vast majority of the 91,000 Washingtonians who rely on Title X program. Our Title X patients come from around the state, and they are from many different backgrounds, from the homeless youth with a urinary tract infection to the stay-at-home mom who needs cancer screenings and birth control. Most of our Title X patients live below the federal poverty level and would not otherwise be able to find the preventative and life-saving care that Title X provides. Many of the Title X patients who receive care at Planned Parenthood are from rural communities and communities of color who already face numerous systematic barriers to health care. Already, in many counties, Planned Parenthood health centers are the only places that provide uninsured or people of low incomes the reproductive health care that they need. Community health centers themselves say that there's no way that they could fill the gap if Planned Parenthood is forced to turn away thousands of Title X patients. Destabilizing the Title X program will also put family planning education services at risk for the more than 18,000 people who rely on Planned Parenthood for these lessons. That is the last thing that Washingtonians need. And that's why when the rule was first proposed, the Washington Department of Health said it would be hugely disruptive to our state. The gag rule is unacceptable. Planned Parenthood will always be here for our patients. We will continue to fight for a world in which everyone has the freedom and opportunity to control our lives at the most basic level, our bodies, our families, and our life's path. Birth control is health care. Cancer screenings are health care. Reproductive health care is health care. And health care is a human right. The Trump-Pence administration may not think you deserve care, but we do. Thank you. Next, I'm going to have the pleasure of introducing Dr. Oyer from the Cedar River Clinics.
Good morning. I'm Dr. Deborah Oyer, and I'm Medical Director of Cedar River Clinics, and I'm here to represent healthcare providers and our patients. For 40 years, Cedar River Clinic has provided high-quality, patient-centered reproductive health care to people in Washington State and beyond. We have always fought to ensure and expand access to this care, and the Trump administration's move to blatantly gut the Title X program shows us that the fight must go on. The new policy is a direct assault on access to essential health care and demonstrates a clear and dangerous disregard for the role that birth control, STI testing and treatment, cancer screening, and other related preventive services play in public health and individual lives. As a family planning provider for 30 years, I've been privileged to have patients trust me with the intimate details of their lives and their care. And in return, I treat them with respect, I assure their privacy, and I give them complete and honest information about their health care. The policy change to Title X requires me to withhold important information from my patients. In addition, the new rules mandate discrimination. Patients with health insurance will continue to get complete information from their providers. However, substantial information will be withheld from low-income patients receiving care in Title X clinics. Even upon a patient's request, medical professionals will be prohibited from providing certain information and support. For example, the rule requires that requests for abortion referrals from patients be answered only with a written list of primary care providers, and it states that the majority of those providers must not provide abortions. So we are being directed to actively mislead our patients. With 60% of abortions being performed by independent clinics like Cedar River and 35% provided by Planned Parenthood, and only 1% in physicians' offices, it is clear that this is an attack on abortion information and access. We believe our patients, no matter their demographics, must be able to get complete information from their providers when making healthcare decisions. They need to be able to access full-spectrum reproductive health care, which includes life-saving access to preventive care and contraception, as well as referral for abortion when needed. We thank Attorney General Ferguson and the others prepared to take on this with a stand to protect the mission and integrity of the Title X family planning program. Cedar River Clinics is committed to defending reproductive rights in health care. We cannot stand by while this administration plays politics with people's lives. So Cedar River Clinic, in addition, is filing a joint lawsuit with the National Family Planning and Reproductive Health Association against the Trump administration. We will continue to fight for patients everywhere because we have a vision of a world where we are all free to make our own decisions regarding our bodies and reproduction, and free to live healthy, self-determined lives with dignity. Thank you. And next, I'd like to introduce Edith Chang, who is the legal director of ACLU Washington.
Oh, it's hazardous here. Yeah, it's some liability, Bob. Good morning, everyone. My name is Emily Chang, and I'm the legal director at the ACLU of Washington. And thank you, Attorney General Ferguson, for hosting this wonderful gathering this morning. The ACLU believes that all American women should have the right to shape their stories, which includes deciding with whom they wish to partner, whether they want to partner at all, and whether they want to have a family. And we believe we should all have this right, regardless of our financial means. Congress agreed too when it structured the Title X program, which the Trump administration now seeks to eviscerate. The unlawful rulemaking promulgated by HHS will make it difficult, if not impossible, for low-income women to engage in any sort of meaningful family planning, threatening the health and well-being of millions of Washingtonians in our state. The administration's new requirements will force health centers across the state and around the country to choose between shutting down or providing substandard medical services. Those who rely on them, primarily families with lower incomes and those living in rural communities, could lose desperately needed health care. None of which makes any sense, because no one should want a dramatic increase in the rate of unintended pregnancies and sexually transmitted infections. And if that's precisely what will happen if relief from this rulemaking is not granted. Which is why the ACLU is proud to stand with the Attorney General and will also bring suit to stop the Trump administration's changes to the Title X program. We look forward to representing the National Family Planning and Reproductive Health Association, Cedar River Clinics, and Dr. Oyer. Thank you all for being a part of this important fight. And I'm now happy to introduce Claire Coleman, the president and CEO of NFRA, the National Family Planning and Reproductive Health Association.
Thank you, Emily. I am the president and CEO of NFRA. We are a national association founded the year after Title X was enacted, and we are a coalition of nearly 900 providers of family planning and sexual health care nationwide, including the state of Washington, including Cedar River Clinics, and including Planned Parenthood of the Great Northwest and Hawaiian Islands. Together, we share a commitment to care for the poor and the low income, a commitment that is written into congressional intent and the Title X statute from 1970. Title X was intended to equalize access to modern contraception, and it continues to deliver on that promise today. But it also stands as the gold standard for how we would want sexual and reproductive health care in this country to be delivered. When you go across the country, Title X providers do not have a label on their door. They do not all look the same. Just the perspective of Cedar River Clinics and Planned Parenthood in Washington State gives you that sense. But whether you are Womankind in Key West, Florida, or Access Esperanza on the border in Texas, or Maine Family Planning, your doors and buildings may look different. You know it's Title X by the way you are treated. From the way you are received at the front desk and the counseling and education that you receive, to the broad range of contraceptive methods, including the newest, most effective, and sometimes most expensive methods of contraception, Title X health centers lead the way. In fact, we are required and proud to be held to the national standard, Quality Family Planning Standard, introduced in 2014 by the Centers for Disease Control and the Office of Population Affairs, the federal office that oversees all Title X all across the country. We are absolutely outraged by the Trump administration's decision to annihilate this successful, proven public health necessity. Women, men, and adolescents need access to confidential, high quality care no matter where they live. And one of the extraordinary successes of Title X is that throughout the country, you can find a Title X provider, whether it's a county health department or a private not-for-profit, in nearly every community, certainly in nearly every county in this country. That means people can get the time-sensitive access to life-saving care they need and deserve. I am not only the president of NIFRA, I come from the Title X network. And I can tell you, as represented by Dr. Oyer at Cedar River and Dr. Berry at Planned Parenthood and this astonishing group of people behind me, that there are no better people working in sexual and reproductive health care today. They keep up with the research, they know what the best practices are, they participate in innovative models, and together they craft extraordinary amounts of service. And they do it all with the lens of the poor, the low income, and the vulnerable in our society. Isn't it extraordinary that this administration should choose to inflict their ideological agenda against the least among us? Together we stand, proudly with Attorney General Ferguson, with Cedar River, with Planned Parenthood, and our other partners around the country, thrilled to be partnered with the ACLU in their extraordinary work to defend the rights and health of all people in this country. It is time for us to say that the program must be protected. Confidential, high-quality care is an honor that we have. We will continue to do our good work, and we will continue to take this fight all the way to the end. We must protect high-quality family planning and sexual health care in this country. Thank you, Attorney General Ferguson. We're glad to be with you.
So thanks to all the guests and our speakers, and we'll start with some questions here. We'll move to folks on the phone. Joel, why don't we start with you? And I'll do my best to repeat the questions, and speakers, remind ourselves to, as we come up to answer questions, to remind the folks on the phone who we are.
Two questions. The first, do you anticipate that other states will be following Washington's lead in filing lawsuits, and which of these states will there be? Secondly, a very somewhat obscure federal law, the Administrative Procedures Act, has been a major weapon that the state has been able to successfully use in these legal actions.
Yes.
Is it applicable again to this case?
So two questions. One is, will other states be filing lawsuits similar to ours? And number two, I think Joel mentioned the Administrative Procedure Act, the APA, which has been, as Joel mentioned, in many of our lawsuits, has been a key part of our legal challenge to the administration. Is that a piece of this case? So the answer to the last question, Joel, on the APA is yes. An APA challenge is a key part of our legal challenge yet again. And number two, I think you're asking about other states. I guess I'll let my colleagues sort of speak for themselves. There's been a lot of communication amongst AGs. I think I'm confident saying that yes, you'll see other lawsuits filed by other states. I don't want to get out ahead of my colleagues on whatever announcements they may have, but I'm confident that Washington State will certainly not be the only state that initiates litigation challenging this unlawful rule. Other questions from those? Yes.
The Reagan administration proposed similar rules that were ultimately upheld by the Supreme Court. Why is your challenge going to be different?
Does anyone on the legal side want to take it? So the question is, sorry, just to rephrase that, I think you're saying the Reagan administration, you're saying there are similar rules in your phrase that were upheld. How would this be different? I'm going to ask Kristen or Jeff or someone from the legal team if they want to. Do you want to address that?
Sure.
Yeah. This will be Jeff Sprung, who's an assistant attorney general in my office.
Thank you. So the rule that was addressed by the Supreme Court was issued in that rule was issued in 1980. The Supreme Court ruled 8 years later. So since then, there have been two new developments, two statutes passed by Congress that have imposed new requirements on the Title X program. And so that case, Russ v. Sullivan, doesn't address the Title X program and Congress's rules as they exist today.
Is the ACA one of the new statutes referring to?
Yes, that's right. And then the other one is a Congress passed a provision and has passed it every year that Attorney General Ferguson referred to, the Consolidated Appropriations Act, that requires pregnancy counseling in the Title X program to be non-directive, not to direct a person in one direction or the other.
Watch your step on your left.
Thanks, Bob.
And one thing I'll just add is, I don't file a lawsuit unless I'm confident we're going to prevail. We've won 17 consecutive cases against this administration. This is our 34th lawsuit. We have not lost a case yet. In any of the cases we filed on a wide range of issues in federal courts across the country, in decisions issued by judges appointed by Republican presidents and judges appointed by Democratic presidents. Part of the reason, there's many reasons we've been so successful, right? A great legal team, great partners, great organizations, you name it. But I think a key part of it is that the administration continues to enact policies that are in direct contravention to federal law, whether it's, to Joel's point, the Administrative Procedure Act, or as Jeff was saying, Affordable Care Act. This is something that's been repeated over and over and over again. One thing I just will also add is that you haven't spent a lot of time thinking about a lot of litigation we've had against this administration. All these cases are about different things or different impacts. Some are targeting immigrant communities. Some are targeting our environment. In this case, it's pretty clear who's being targeted. But I would say that each of those cases also are about other things as well. And one thing I want to emphasize, which I think the speakers addressed, but I want to emphasize that this case is about placing a political ideology, about placing politicians in the room when doctors and patients are discussing healthcare options. That is unacceptable. That is unacceptable, and it is unlawful. Yes. Oh, sorry, Emily. So Emily from ACLU wants to add to that. Go right ahead, Emily.
I just wanted to add really quickly that, as Attorney General Ferguson mentioned, obviously this case is about access to reproductive health care, but for the ACLU, it is also about checking unfettered executive power. And that is precisely what the Administrative Procedures Act claims get to, that agencies are not allowed to willy-nilly promulgate new law. That is the job of Congress. And it's also about enforcing the separation of powers. And thus far, we have been lucky in a strong judicial system that understands the role that each of our branches of government has to play, and we hope the Trump administration will eventually get the message as well.
Yes, go right ahead.
Why is it important for the state to file this lawsuit when you have nonprofit groups and other organizations filing the lawsuit? Why spend the state's resources on this?
So the question is, why is it important for the state to file the lawsuit when other organizations are filing as well? I think for virtually all of our 33 lawsuits, Noah can help me out, but I think in virtually all the 33 lawsuits that we filed, there have often, if not always, been individuals or organizations that have also filed litigation. So for me, I appreciate many other organizations, individuals litigating as well, but as Attorney General for the state of Washington, my job is to represent the people of the state. If anyone violates the law while harming Washingtonians, they're going to see me filing litigation, whether that's a company, an individual, or the president. That's my job. And so, look, a key part of our success has been organizations working with us, right? The Northwest Immigrant Rights Project when it comes to immigration issues, right? You name it. That's been key to have many voices in that courtroom. But I think it's important for the people of the state to know that the state of Washington, the attorney for the people of the state of Washington, is there in the courtroom expressing our state's opposition to these unlawful policies.
May I add?
Yes, go right ahead. This is Claire.
Hi, I'm Claire Coleman from NFRA. I would also add, of course, that the State Health Department is the legal grantee of the program,
Yes.
and so is directly impacted by every single change that the administration is attempting to impose here. This is an outstanding program with a wide variety of providers, but it is in fact the State Health Department that is legally obligated to comply and to assure to the feds that they are complying. So there is a direct impact on the state as well as all the citizens in the state.
Thanks for that. Why don't we go to anyone on the phone who may have a question, then we'll come back for a couple final questions here. We're also available afterwards for any one-on-one questions that folks have. I know it's tricky on the phone if folks can jump in front of each other on that, but let's give it a shot and see if anyone on the phone has a question.
Yeah, Bob, this is Paul Shakowski with Bloomberg Bureau of National Affairs. since we're going to be seeing litigation in jurisdictions across the country, do you anticipate ultimately that the courts will consolidate it all into one case before one court? And if so, have you had conversations with other attorney generals about that and how you guys might handle it?
As I think folks in the room heard the question. The question went to, hey, if there are different lawsuits filed in different jurisdictions, would all of those lawsuits ultimately be consolidated to one court? That would not be typical, Paul, to your question. It's not unusual to have different lawsuits challenging different actions by the administration. On the Dreamers case, for example, California filed their own lawsuit. Other AGs filed collectively in New York. Those cases proceeded on their own through the court system. So no, I would not anticipate that happening in this case. We'll see how many other states file and whether that's one other action or multiple other actions, but I would not necessarily anticipate a variety of actions filed across the country to be consolidated. I would anticipate that our case, along with NIFRA, obviously, that those two cases in the Eastern District of Washington would likely be consolidated, but that would stay at the Eastern District of Washington. That'd be my expectation. And undoubtedly, I mean, as the cases go forward, I guess I could say if one of these cases will likely end up for the United States Supreme Court. This is a big issue. It is possible once you get to the Supreme Court that cases get consolidated at that point, but I would anticipate our case to move along through the court system here in the Eastern District and the Ninth Circuit, and we'll be prepared to go to the United States Supreme Court if that's necessary. Anybody else on the phone have a question? If not, let's take maybe a couple more here, and then we'll wrap up. We'll go right ahead, Joel. Yeah, go ahead.
Conversation on this sticks with me. I was out at Claylock on the Washington coast at a time when Planned Parenthood was in danger of having to close a small clinic in nearby Forks. The night manager of that clinic talked to me at great length about the difficulty of poor women out there in that area, even getting as far as Port Angeles for treatment. I would like someone up there to talk to those 11 counties and talk to the difficulty that this will cause women in particularly rural and less populated areas of the state of getting reproductive care and of getting family care.
So, Steve, do you mind repeating? You want to go for it? If you don't mind repeating the question, if you're able to, Joel, that'd be great.
So this is Dr. Deborah Oyer from Cedar River Clinics. The question, as I hear it, is how does this impact women who are more rural and farther away from cities? This is a problem in healthcare in general, and particularly in reproductive healthcare, often because of the stigma attached to it, and also because of the timely nature of it. So when we live in Seattle, if I'm a patient in Seattle and I run out of my birth control pills, there are all-night pharmacies where I can go on Sunday night and get the pills I need. If I live in a small community with one pharmacy or without a pharmacy, that pharmacy is likely only open during business hours, and I can't get what I need unless I'm really organized about it the week before I'm about to run out of my contraception. In addition, in order to see a provider, if you have to drive hours to see a provider and you have children that you have to take care of, it becomes really a burden, as opposed to if you have a family planning clinic in your community where you can go in while your kids are in school, have a quick appointment, and actually be handed your medications as well, so you don't have to worry about getting care at the last minute. Family planning care, as Dr. Berry said, is just health care, and we shouldn't put all these barriers up to patients who need their contraception and they need it in a timely manner. Does that answer your question?
Go ahead. What's your step there?
I had a question for you, Attorney General. Have you made a decision on whether to file a suit over the emergency declaration law?
Sure.
Or the wall?
Sure. So the question goes to whether I've made a decision to file a litigation against the Trump administration on the emergency, on the so-called emergency on the border wall. No, not made a decision yet. A couple points. So number one, many weeks ago, I asked my team to prepare a potential lawsuit, anticipating that the president would take the action he ultimately did. That's been prepared, and we believe we have strong legal arguments to challenge that declaration on constitutional grounds. But what needs to be a part of any lawsuit that I bring on behalf of the people of the state of Washington is I need to have standing to bring the lawsuit. I need to be able to demonstrate the harm to Washington State. When my team and I are talking about potential litigation, the questions I'm asking is, are Washingtonians harmed? Do I have standing? And do we have good legal arguments? If the answers are yes, yes, and yes, I'm interested. If there's a no in there, we're not filing or we're waiting. And so, as you know, there are 3 different budgets that the Trump administration will be pulling funds from to pay for the wall. The military construction budget, the MILCON budget, is one in particular that Washington State has many, many millions of dollars of funding in that MILCON budget. Do we think there's a very good chance that the administration will be drawing from Washington-funded projects to pay for the wall? Yes. Do we know that's going to happen? No. And so I don't like going into court challenging a president until I'm very, very clear with the court of what the harm is to Washington State. Right now, we just don't have that. And so that's my approach, and it's worked well for us so far with our litigation against the administration. And I think it's important to communicate to the people that, you know, I don't swing at every pitch. I swing at pitches I think I can hit, right? And when the time is right, we'll do it. But I can say, as the team, folks who are here, we've worked for a long time on that potential litigation. A complaint has been drafted. It's been drafted for some time. But that last piece is absolutely necessary, in my view, for us to file litigation. If we do, that would likely be filed our own litigation here in Washington State. As opposed to joining California, we would likely file our own lawsuit here. So just maybe a final thought, then we'll be happy to stick around for questions. I just so much appreciate, you know, everybody who's been here and the words that they've shared. You know, one of the, all these lawsuits are challenging in their own way. They're all frustrating in their way, that we have to file a lawsuit, that we have to spend our time and energy, in this case, rather than helping women access their health care, to challenging unlawful, unconstitutional action by the president. That said, you know, one of the joys of this litigation is bring all these folks together, activists, individuals, residents of our state, organizations, in a collective effort to stand up to something that we see as so deeply harmful to women across our state. You know, look, it's just not I forget who said it, but it's not the business of politicians to place themselves in the room when a doctor is communicating with a patient. These cases are all complicated in some respects from a legal standpoint. I get that, right? And my team works so hard in the ACLU right, on framing that. But I want to emphasize this. The reason we win case after case after case against this administration is because the cases, in many respects, are simple. They're simple in a certain respect, that the administration flaunts the rule of law. They flaunt it over and over and over again. That's not an opinion, that is a fact. You cannot win 17 straight cases against anyone without something going on that runs deeper than simply a violation of law. And it's happening here again today. So we're confident in our case. We'll be working very, very hard on this case. We so appreciate the support of so many people who came here today. I appreciate all the work on the legal side with the ACLU, with my legal team and many, many others. We appreciate you all being here, and hope you all have a great day. Thank you so much, everybody.